Good afternoon, everyone. Welcome to episode 3 of the Corporation Code. This time we are going to discuss about Title 3, okay? Title 3, the Board of Directors or Board of Trustees and the officers of the corporation. Now, the first topic that we will be discussing is the Doctrine of Centralized Management. No? Now, the Doctrine of Centralized Management states that the corporate powers of the corporation shall be exercised, and all business conducted, and all property of such corporations shall be controlled or held by the board of directors or trustees to be elected from among the members of the stockholders, or when there is no stockholder, from among the members of the corporation, who shall hold office for 1 year and until their successors are elected and qualified. The doctrine of centralized management means, class, that the powers of the corporation and the conduct of its business and the holding of the property of the corporation is to be done by its board of directors. The centralized management refers to the board as the body politic which conducts or transact business of the corporation on a daily basis. All of the powers that are granted to the corporation, say for example, the power to acquire under its name, shall be exercised, and all business conducted, all properties held by the board of directors. Now, the board of directors has a term under section 23 of 1 year, which is why, class, you will take note in the meetings of the stockholders, you will see there that they have the annual meeting. Have you wondered why the stockholders have annual meetings? That is for the purpose of electing the board. The board of directors are elected on an annual or yearly basis. Because again, no, the board of directors shall hold office for 1 year and until their successors are elected and qualified. Now again, the doctrine of centralized management pertains to the exercise of the powers to the conduct of all business and the control and holding of all property of the corporation. Now, another concept that I want to share with you is the business judgment rule. Now, class, okay, if a particular stockholder, no, for example, will find that the decision of the board of directors in investing in another business is too risky when it comes to financial matters, no? Can the stockholder go to court and question the decision or action of the board of directors? In other words, class, can a stockholder, no? Does the stockholder possess the right to question or to raise the wisdom, for example, of the decision of the board of directors respecting investment in another business? Now, the answer, class, to that question is no. The stockholder cannot go to court to question the wisdom of the decision of the board of directors. Why? What is the basis for this answer? The basis is the business judgment rule. Because class, the court cannot substitute its judgment to the judgment of the board of directors. As long as the judgment or the decision or the particular act or acts committed by the board, no, pertains to a legitimate power of the corporation, or that the contract was entered into within the powers of the board, then this administrative matter may not be interfered with by the courts. The court cannot undertake to control the discretion or to substitute its judgment with the judgment of the board of directors. Because, class, the board of directors will have to exercise the powers in accordance with their better judgment. Okay? So all contracts entered into by the board of directors are binding upon the corporation because the powers, again, are exercised by the board. Now, the courts will not interfere in any contract entered into by the board, no, unless the contract, and these are now the grounds for the court to intervene, no, in any matters taken up by the board of directors. Now, unless the contracts are unconscionable and oppressive as to amount to a wanton destruction of the rights of the minority. Unless, class, the action taken up by the board of director is so unconscionable. Ano ba yung unconscionable na yan, class? Meaning to say, it is shocking to the conscience of man. It is apparently unfair or illegal, no? Then this will now entitle a particular stockholder to question the decision of the board of director. But unless and until that this act will qualify as an unconscionable and oppressive, no, amounting to a wanton destruction of the rights of the minority, the courts cannot entertain any question with respect to the decision or the business judgment of the board of directors. Now, there are certain exceptions which I want you to remember. Now, under these exceptions, the court may step into, no, or the courts may interfere and invalidate, for example, the decision of the board of directors. What are those exceptions? The first exception is when the corporation code provides. If the corporation code provides, no, that for example, a stockholder can assert a particular right, then the courts may step into and interfere with the decision of the board. For example, class, no? A stockholder has the right to inspect the corporate books. If this right of the stockholder, no, is violated, then the stockholder can go to court and seek relief, no, and the court can order the board of directors to allow inspection of the corporate books, because again, this right is provided for under the corporation code. If I'm not mistaken, that is under section 79 of the corporation code. Now, when the directors or officers acted with fraud, you learn this concept from the law on obligation and contracts, gross negligence, and in bad faith. No, if the board of director is in bad faith, take note, class, that the negligence must be gross in character so as to warrant the exercise of the exception to the business judgment rule. Now, the third one is when the directors or officers act against the corporation in conflict of interest situation. Okay, now, again, the term of the board of director is 1 year. But if after 1 year, wala pa ring election, no, by the stockholders, no, the election has not been conducted, this elected board of directors have the capacity to extend. Ang tawag dyan is in holdover capacity. Ibig sabihin, class, tapos na yung term nila ng 1 year, but because wala pang elected board of directors, no, the successors have not been elected and qualified, then the existing board of directors can still extend their term, no, in a holdover capacity. Upon failure of a quorum at any meeting of the stockholders called for an election, the directorate naturally holds over and continues to function until another directorate is chosen and qualified. Now, you will see here a distinction between a stock corporation and a non-stock corporation from the point of view of a board of director. Now, it is required for a board of director to own at least 1 share. This is very basic, class. Hindi ka pwedeng ma-elect na member ng board or ng board of director, as a member of the board of director rather, if you do not own at least 1 share. No, you need to own at least 1 share in order to qualify for the election of the board. That goes without saying that if you are not a stockholder of a corporation, you cannot be elected as elected in the election of the board of directors. Now, in a non-stock corporation, since there is no stock, no, there is no authorized capital stock. No, the requirement is that the board of trustee or the person to be elected in the board of trustee must be a member in good standing of the non-stock corporation. Okay. Now, the second distinction is that the stock must be registered in his name. Class, anong ibig sabihin ng that the stock is registered in his name? Okay. Minsan, class, may mga stockholders na ayaw nilang ilagay ang shares of stock sa pangalan nila for some reasons. For example, nasa abroad, no, ayaw niya mag-process ng papers, in which case it will be more convenient to choose a representative to transfer the shares of stocks in favor of the representative. Now, kapag nilagay yung shares of stocks under the name of the representative, that representative is now the one or the person qualified to run in the board of in the election of the board of directors. Now, ang tawag natin doon, class, sa true owner ng stocks is a beneficial owner. No, beneficial owner. Siya talaga yung may-ari, ibig sabihin siya yung nagbayad. It's just that it was registered, no, the shares of stocks was registered under the name of another person. Okay. Ang tawag naman natin doon, class, doon sa person na ipinangalan yung shares of stocks, kahit hindi sa kanya yun, is the naked owner. Naked owner. The beneficial owner is the real owner, and that the person under whose name the shares of stocks was registered is the naked owner. Now, the person, no, in whose name the shares of stocks are registered is the one qualified to run in the board, in the election of the board of directors, not the beneficial owner. Now, a majority of them must be resident of the Philippines. On the other hand, only majority of the board is required to be residing in the Philippines. Now, if you cease to own at least one share, it goes without saying that you are now disqualified or you can be removed as a board of director. Okay. Now, class, we've discussed this during part 2 of this series of video, that only natural persons can be elected as member of the board or member of the board of trustees. Again, why? Because, class, under the old corporation code, di ba, the rationale behind the old corporation code is that a corporation would not be an effective member of the board because it will have to choose its representative in order to participate or partake in the management of the corporation. Now, however, a corporation can choose its representative to sit in the board. This is the exception. That only a natural person can be elected as board of director. Now, class, you will take note in your further reading of the corporation code. May makita kayo dyan, class, voting trust agreement or VTA. Voting trust agreement. Actually, I have prepared a voting trust agreement in favor of a client. Ganito yan, class. What is a voting trust agreement? For example, you are a stockholder and meron kang pinagkakautangan, you obtained a loan from another person. Now, class, pwede mong iprenda yung shares of stocks mo. When you say prenda, you can transfer your shares of stocks in favor of your creditor as a security for the payment of the loan. Ang tawag sa'yo, you are the stockholder trustor and he is the creditor trustee. Now, class, your creditor trustee, No, in a voting trust agreement can be elected as member of the board. Why? Kasi class, if you execute a voting trust agreement, what the corporation will do is to cancel the shares under your name and transfer it in favor of the trustee or the creditor of the stockholder. Now, pag kinancel yung shares under your name and tinransfer siya in favor of the creditor or trustee, then that creditor trustee is now qualified to be elected in the election of the board of directors or the board of trustees. That is the concept of a VTA or voting trust agreement. Now, class, there are certain qualifications. No, meaning to say, if these circumstances would exist, then you cannot run in the election of the board. What are those? Now, if you have been sentenced by a final judgment for an offense carrying an imprisonment of more than 6 years, o class, tandaan nyo yan. Importante yan. Ang nakalagay sa batas, class, more than 6 years. Baka ang tanongin na naman sa inyo sa exam, 6 years eksakto. So magko-confuse na naman kayo if the disqualification will apply. Remember that the disqualification will apply only if the imprisonment exceeds 6 years or the imprisonment imposed is more than 6 years. If it is 6 years or below, then you are not disqualified for the election of the board of directors. Now, another instance wherein you can be disqualified is when you are convicted of an offense, no, of the violation of the corporation code. If you have violated any provision of the corporation code, no, then you can be disqualified to run in the election of the board. Now, class, the most important qualification is the last phrase, no? 5 years prior to his election or appointment. What do we mean by this? That means, class, that even if you have been sentenced for an offense with imprisonment exceeding 6 years, or if you have violated a provision of the corporation code, but the imprisonment or the violation of the corporation code has not been committed or have not been committed 5 years prior to your election or to the election of the board, then you are qualified. Take note of that period of time. Just because you suffered a sentence of an imprisonment more than 6 years does not mean or does not automatically disqualify you from what? From the election of the board. Only when the imprisonment, no, has been imposed to you 5 years prior. No, 5 years prior to the election that you are now disqualified. Okay. Take note and take note. Okay. Class, in order for the election of the board to take place, it is important that there is a presence of the quorum. The quorum refers to majority of the capital stock or the members. Now, syempre, pag members, wala yung shares of stocks. Therefore, bibilangin mo yan kung ilan yung members and then majority or the quorum, no, majority plus 1, that means 50% plus 1. That is the quorum which is required to hold an election. Okay. We have an example here, no? So for example, A owns 100 shares of stocks in a corporation and 5 directors are to be elected. A is entitled to vote 500 votes or number of shares times the number of directors to be elected. So 500 votes. So class, you can vote as much as the number of shares that you own. Okay. There are some No, balik muna tayo dito, class. Tandaan nyo. Okay. Ito, meron ako ditong trick. Okay. Now, class, kung ang subscription mo ay 100%, 100 shares, pero ang binayaran mo, 25 shares lang. Ang tanong, pwede mo bang iboto yung entire 100 shares? Diba? Hindi ka naman required na fully paid ka for your shares. Diba? Hindi yan requirement under the corporation code. You have subscribed for 100%, or for example, ang binayaran mo is only the 25 shares. No? So, the question is, can you still vote for the entire shares or only for the paid shares? Answer, for the entire shares, class. Unless you are declared as delinquent. Tandaan nyo yan. Ha? Importante yan. You can vote for the entirety of your subscription, your subscribed shares, and not only with respect to your paid up shares. Unless, again, you are declared delinquent, in which case you cannot vote or be voted upon in the election of the board. There are several types or kinds or manners which you can vote. Pag straight voting, 100 shares, 5 directors, no? Ang ibig sabihin niyan, iboboto mo sila tigi 100. O, I will vote my 100 shares, or you can distribute the 100 shares equally, 20 shares for A, 20 shares for B, etc., etc. That is what you mean by straight voting. No, you are voting for as many persons as there are directors or vacancies. Okay? When you say cumulative voting, for example, you have 100 shares, you can put all your eggs in one basket, so to speak. No, pwede mong iboto yung entire 100 shares mo in one candidate. That is what we mean by cumulative voting for one candidate. And then cumulative voting by distribution, you distribute among the candidates, no, as you see fit. Okay? Okay. The corporation states that the total number of votes cast by stockholders shall not exceed the number of shares owned by him. And again, class, no delinquent stock shall vote or be voted upon. Now, quorum, majority of the number of the board of directors. No, majority meaning 50% plus 1. Okay, class, just be conscious about the difference between these phrases. Pag sinabi ng batas, majority vote of all directors or trustees, magkaiba yan sa majority vote of the directors or trustees constituting a quorum. So former class, ang tinatawag natin dyan, absolute majority. Ibig sabihin, majority ng lahat. Kung 5 yung directors, no, yung board of directors, 5 sila, ang majority dyan, 3. Pero alimbawa, 3 lang ang present. Nagbotohan sila. Ano ang simple majority dyan? 2. No, 2 votes. Pag ang requirement ng batas, majority of all, kailangan kahit 3 lang ang present, yung 3 na yun bumoto in order to qualify the transaction or to make the action taken upon or taken up as valid. Now, if the requirement of the law is majority of the directors constituting a quorum, kung 3 lang kayo, pwede na ang 2. Okay, that is what is absolute majority and simple majority. Class, how do you remove a director? Tandaan nyo lang, class, yung voting requirement. By a vote of stockholders representing 2/3 of the outstanding capital stock or 2/3 of the members. And then just familiarize yourselves with the other requirements of the law. You will take note that the board of directors has no power to remove one of its members as director or trustees. Tandaan nyo yan. Baka mamaya itanong yan sa exam, tapos hindi nyo masagot. Pag ang choices dyan, majority of the board plus 2/3, or majority or 2/3 lang, or none of the above, your answer is letter C. Because the board of directors has no power to remove one of its members as director or trustee. Now, class, Just like a partnership, a director also has a fiduciary duty. When you say fiduciary duty, the power of a director is a power of trust, not trust and confidence. Not the director cannot manipulate the affairs of the corporation to the detriment and in disregard of the standards of common decency. This is what you mean by the principle of fiduciary duties and liability. Okay. Duty of obedience. The board of directors must adhere to the bylaws of the corporation. No? Any director violating the duty of obedience shall be liable for ultra vires. Class ultra vires is a Latin term which means what? It is an excess, no, or excessive power. Okay. Duty of diligence, no? Okay, what is duty of diligence? No, director or trustees who willfully and knowingly vote or assent to a patently unlawful acts of the corporation or who is guilty of gross negligence or bad faith. Class, ito yung mga offenses that can be committed by the board of directors. Pag bumoto siya to a patently, pag sinabing patently, class, ibig sabihin, maliwanag pa sa sikat ng araw na illegal yung kanilang transaction or illegal yung act na i-authorize ng corporation. Now, if you are also guilty of gross negligence or bad faith, then class, you will be jointly and severally liable for all the damages. Class, you relate this section 31 to the law on obligation and contracts. When you say jointly and severally liable for all damages, what is the nature of the obligation? Is it a joint obligation or a solidary obligation? What is the answer? Or if you remember your law on obligation and contracts, what do you mean when you say jointly and severally liable? Solidary liability. Tandaan yan. Pag hindi nyo yan nasagot, at kayo yung, at ako yung prof nyo sa Oblicon, I will deny you 3 times. Okay. Now, again, these are the circumstances wherein a director can be personally liable. No? If you have voted for a patently unlawful act, etc., bad faith, gross negligence, if you have consented to the issuance of a watered stocks, class pag watered stocks, ibig sabihin, no, you are making it appear that there is you are selling the shares for more than its par value, watered stock, no? We will discuss this in detail later on. Now, if you have consented to the issuance of a watered stock, no, for original issuance of shares, then you can be held personally liable for damages. And the liability, again, is a solidary liability. Now, if you have agreed to hold yourself personally liable, you will be personally liable. And when there is a law that makes a director personally liable for a corporate action. Duty of loyalty, no, the generic definition or generic sense of loyalty, that means that you cannot take any adverse interest against the corporation. Now, class, I want you to remember this concept of self-dealing directors with the corporation. Now, class, tandaan nyo ito. If a contract entered into by a corporation, no, ang party sa kontrata is the corporation and one or more of its directors or trustees. Again, ang party sa contract, party A si corporation, party B is one or more of the board of directors or board of trustees or the officers of the corporation. What is the status of the corporation? Of the contract rather. The status of the contract is voidable at the option of the corporation, which means that the only party who can ratify this voidable contract is the corporation and not the board of directors, trustees, or officers. Now, the status of the contract is voidable except under the following conditions. The presence of the director is not necessary to constitute quorum, or for example, the vote of the director is not necessary for the approval of the contract, or the contract is fair and reasonable under the circumstances, And lastly, the contract with the officer has been previously authorized or approved by the board of directors. In any of these instances, no, the contract will not be voidable. Ha? Tandaan niyo yan. So as a general rule, no, the contract is voidable, no, except under the following conditions, which means to say that, oh no, sorry, these four requirements must all concur. Dapat meron dito yan after ng third end, word end, A and D. Dapat yung apat na yan, kaya memoryahin nyo yan, class, memorize. Dapat yung apat na yan must concur or are all present so that the contract is not voidable at the option of the corporation. Okay, dealings with, in the absence of the first two conditions, ratification may be made by a vote of stockholders representing at least 2/3 votes of the members. Okay. Dealings between corporations with interlocking directors. Minsan, class, yung mga directors na yan, director din ng ibang corporation. Now, what if Corporation A and Corporation B, meron silang common directors? Ang tawag ng batas dyan, interlocking directors. As a general rule, a contract between two or more corporations having interlocking directors shall not be invalidated on the ground alone, except if there is fraud or the contract is not fair and reasonable under the circumstances. Now, this requirement under Section 2 must be complied with to make the contract between the corporation and interlocking directors valid. And when you say stock holdings, when you say substantial interest, that means stock holdings exceeding 20% of the outstanding capital stock. Now, class, what is a management contract? A management contract, class, is where you delegate some matters with respect, wherein you enter into, the corporation will enter into a contract to another corporation or an individual person for the management of the corporation. Ang sabi ng batas, management contract cannot delegate the entire supervision and control over the officers and business of the corporation to another corporation, no? For this will contravene the fundamental rule that the corporate powers are exercised by the board. Okay. So, management contract ang tawag dyan. Now, class, okay, the majority of the members of the board, no, of the managing corporation also constitute a majority of the member of the board of the managed corporation. The vote required is that what? The management contract must be approved by the managed corporation owning at least 2/3 of the outstanding capital stock. Class, take note lang. Sa management contract, nag-a-apply lang itong requirement, no, that the management contract must be approved by the stockholders of the managed corporation owning at least 2/3 of the total outstanding stocks. Class, nag-a-apply lang yan if the management contract is entered into between two corporations. Pag hindi two corporations, class, do not apply the rule. Okay. The executive committee. Okay. The bylaws of a corporation may create an executive committee. Ang tinatawag natin na execom, class. Execom. Diba? Which is composed of not less than, hindi bababa sa 3 miyembro ng board. No? To be appointed by the board itself. Okay, class, ano ba yung executive committee? No, yung executive committee, kasi minsan, hindi mahagilap lahat ng board or laging walang quorum. Or kung may quorum, di sila, kumbaga, mahirap ma-attain yung attendance ng members of the board. So, ang ginagawa nila, nagki-create sila ng executive committee so that certain matters within the competence of the board can be delegated to a small number of persons instead of 5. Magiging 3 na lang for the executive committee. No, the purpose of which is to take off part of the work of the board during the periods when the board does not meet. No? There are several matters which the executive committee may not act on. For example, approval of any action which requires the shareholders' approval, no? Or filling of vacancies in the board. They cannot fill it. no, any vacancy or amendment or repeal of any resolution of the board, the executive committee cannot overturn or cannot amend or cannot repeal any resolution of the board, no, which by its express terms is not so amendable or repealable, and distribution of cash dividends. These are the matters which are not within the competence of the executive committee. So this ends Title 3, no? I will see you again on Title 4, okay, of the Corporation Code.